Welcome to our seminar summarizing the bills passed in the Texas 89th legislative session in 2025. This is part of our C.I.A. Services Associations and Practice series, where we try to provide valuable insights into topics of interest to community volunteers like you. My name is Ralph Troiano, and I'm pleased to be presenting this information. C.I.A. Services has been managing communities in Texas since 1984. Let's start with some background. The Texas legislature meets every 2 years for 140 days. That's part of our Texas Constitution. The first session was held in 1846, shortly after Texas became a state. This year's 89th regular session began on January 14th and ended on June 2nd. There were almost 9,000 bills filed, and about 70 could possibly impact property owners associations or condominiums. But normally only a small fraction of the bills that are filed actually become law. Over the last 3 sessions, it's only averaged 14% of all the bills filed. Now, the 89th session had its normal share of bills aimed at POAs. So let's go ahead and review. Let's start with what didn't pass. There were some bills of significant concern, and in the preview seminar we did a couple months ago, we covered those. But to summarize, here are the bills that didn't pass, that either were concerning or just didn't make it. First one was related to architectural authority. That would have prohibited a POA from restricting an owner from making minor aesthetic improvements. And in the bill they cite painting, specifically any color that the owner would want, building a fence, or landscaping. The challenge with that one was it simply said minor aesthetic improvements, which would be subject to anyone's opinion. There were a couple bills which dealt with assessment increases. One of them that was filed in the Senate would have limited assessment increases to 5% unless more than 50% of all owners approved it. And it wouldn't matter what's in the governing documents themselves, which may have a number higher than 5%. This would limit it by state law. And then that House Bill 5225 would have limited increases of an unreasonable amount without approval from a majority of owners. It's not clear who would decide what is unreasonable. And then we had a couple bills which dealt with board vacancies. And what those would have required is, if there was a vacancy, a board member resigns, passes away, moves away from the community, whatever it might be, that the POA was required, not could, should, or might, but would be required to hold a special election to fill that vacancy. The vacancy could not be filled by a board appointment. And the other part of it was that the person elected would only serve until the next annual meeting, which may be, it certainly would be less than 12 months from now. It could be 2 or 3 months from now, and they would only serve for that period, even if there was more than that time before that term would be up. We had another group of bills that had to do with chickens, rabbits, and gardens. That did not pass. I was actually expecting the chicken bill, one of the chicken bills, to pass this session. But it would have allowed up to 6 chickens, 6 rabbits. It would allow fruit and vegetable gardens on properties, and it would have allowed residents to conduct cottage food production at their property. That would be making food in bulk for sale. That could be done at a property. It didn't pass. Closing support. This particular bill would have capped the amount that an association or its management company could charge for all documents in support of a sale at $375. Today, that happens to be the cap that applies to resale certificates. And today, additional fees can be charged depending on what a title company wants in order to proceed with the closing. There may be documents called demands, there may be estoppel letters, there may be 60, 90-day letters, there could be loan certifications. There could be, even though the current law allows up to 10 days to deliver resale certificates and other documents, sometimes they need them faster. This law, if it had passed, would not allow an association or management company to file a rush fee or charge a rush fee. Short-term rentals. This bill would have prevented a POA from prohibiting short-term rentals. Even if the owners had gotten together over the last several years, filed a amended declaration that prevented short-term rentals. So it would have overridden anything that an association might have. And finally, the Texas Real Estate Commission was pushing to require POAs to file all their dedicatory instruments or governing documents with a TREC website. Keep in mind that there's already a requirement that all these governing documents be filed in the public records of the county in which the community is located. And there is a requirement that all dedicatory instruments or governing documents be posted on an association website. So this would have added a third place that the documents need to be filed. Well, let's go on to the things that have passed. We'll start with solar energy devices. In 2011, the Texas Property Code was amended to protect the right of owners to install solar energy devices. Primarily, that's roof or ground mounted solar panels. At the time, there wasn't anything called solar roof tiles. That technology wasn't in place yet. Those have since been commercialized, so what has passed is including solar roof tiles in terms of what is allowed as a solar energy device. And what they look like are really just gray shingles or clay tiles. So they come in various styles. I specifically provided some photos here. On the left-hand side, you can see ones that almost look like slate roofing. And the ones on the right, the blue ones in there, are looking like clay tiles, except for the color. The shape is that. This law is already in effect. It went into effect on 5/29. In the legislative session of 2021, there was a law that was put into place which had some issues. In 2023, the legislature tried to clean those issues, but the governor did veto it. Those have been reintroduced in 2025. There's a couple of these that had the problems, attempt to clean it up, a veto, and were reintroduced. The 2021 bill was relatively short. It's regarding fencing. It basically said an owner may install a fence anywhere on their property if the owner considers it a security measure. The law is pretty broad here. It doesn't take into account where a fence could be. It says they simply can't install it. It only had limited ability for an association to regulate the appearance of that fence or the size of that fence. And so in this 2025 amendment, now the association can prohibit placement that would enclose a shared common area, maybe a common parking area, that would enclose a public sidewalk or impede a public sidewalk, or a drainage area. The association can also prohibit a driveway gate that's within 10 feet of the road right of way. In other words, you wouldn't want a situation where a car would pull into the driveway, have to open the gate, and have the back end of the car sticking into the road. So the 10-foot setback would avoid an issue of a vehicle endangering other vehicles as they try to open the gate. And the law also that has taken effect, will take effect on September 1st, does allow an association to prohibit a fence in front of the house if the existing dedicatory instruments already indicate the fences must be at the house or backwards. Well, let's talk about droughts. Local authorities and water providers are imposing mandatory water restrictions more frequently than in the past and for longer periods, because we have for many years have had less rain and higher temperatures. In the San Antonio area, we've been on drought restrictions for about 3 years now, a little over 3 years. So it's continuous. Summer, winter, we've been on restrictions. And so when you are on watering restrictions, the regulatory agency, either the local authority or the water provider, indicates how often you're able to water. In some cases, in San Antonio, the authority indicates even the quantity of water you can use before you are charged a very significant surcharge. And so if you're not able to water, if an owner's not able to water their grass, their turf, their shrubbery, their trees, it can lead to discolored, brown, or even dead plant materials. So the section that's been added to the Texas Property Code says that during these mandatory water restrictions, a POA may not fine someone, if they have the fining authority, for a violation relating to their vegetation or requiring them to replace, maintain green vegetation. Once a water restriction is lifted, the prohibition for fining will stay in place for 60 additional days. So in other words, once you can start watering, there's a 2-month period which hopefully you can get your vegetation to come back. This is an interesting one. In the hill country and even in urban areas, we have a whole lot of deer in Texas. The white-tailed deer are the most common ones that we see everywhere. And so what has been added to the Parks and Wildlife Code is the ability for POAs and other entities, whether they're governmental, schools, the ability to control white-tailed deer by lethal means. Clearly that means killing them. The entity needs to be experiencing an overpopulation issue on association property, and specifically on property where hunting is not allowed. So any residential association, except very, very large ones with large acreage properties, would be in a situation where people are not able to hunt inside the community. The law also would allow the ability to take care of whitetails if the deer are damaging the habitat of endangered species, which is an interesting thing. For an association, we're talking about overpopulation on association property. In order to do this, a request must be made to Texas Parks and Wildlife Department. They will investigate to determine if you really have an overpopulation issue, if control uh, systems are in place right now, such as fencing and things of that sort, um, that still don't solve the problem. And they will determine if the situation qualifies for granting a permit. It's not clear exactly how the population will be controlled by lethal means, because specifically, hunting is not allowed in especially suburban type communities. This one hasn't been signed by the governor yet, but it will take effect on September 1st. One of the things that um, is different in the Texas Property Code is that property owners associations are covered in different sections of the property code than condominiums. Condominiums are under Chapter 82, which is referred to as the Uniform Condominium Act. It's one chapter, very long, covers everything. There's no equivalent for POAs, so we've got a bunch of chapters, the 200 series chapters, 16 of them, which deal with POAs. There are several administrative provisions that are in both. The condominium ones started earlier than the POA ones, but each one has been independently amended over the years, and so the two really have drifted apart. In this legislative session, there was an attempt to make the condominium requirements consistent with those for property owners associations, which have had the most improvements and changes and modernization. So condominiums now must file dedicatory instruments on association websites, just like POAs do, and made available to members. Condominiums must prepare management certificates with the same information that POAs have and file those in the county public records. Those management certificates must also be filed with TREC, just like POAs. And finally, we talked about resale certificates earlier. Now with condominiums, they have the same $375 cap as POAs do. So this brings them consistent. They're both residential ownership structures or associations, and so it makes sense that they should both have similar rules under the law. Especially since COVID, there's been more and more associations which are meeting by what the law says electronic or telephonic means. So language has been added for both POAs and condominiums to make it clear that that is allowable. Even if your documents say the board must get together and meet, the law says that you can get together virtually on a phone call or a other electronic platform to meet. In condominiums, voting may take place electronically now. POAs have had this right since 2011. It wasn't available to condos until this year, or with this session. When we get to POAs, there are 4 methods since 2011 that the property code allows owners to vote. Independent of what's in their bylaws, there are 4 ways to vote under the Texas law. People can vote in person at a meeting. They can vote through a proxy at a meeting. A proxy is a human being that has the right to vote on behalf of someone else, by absentee ballot or by electronic ballot. Great, that's been around for a while, since 2011. The law clarifies, though, that an association is not required to offer all of those methods of voting. They must offer at least one. And it's not one of the four, it's one of these three: absentee, proxy, or electronic ballot. I've always found it interesting that that meeting in person is not one of the things that must be offered. But the other three must be offered, and at C.I.A. Services, we are typically offering all four unless there are special circumstances. This is an important one. We had, again, something introduced in 2021 that created problems for architectural review committees. The governor vetoed that bill, the cleanup bill, in 2023, but now it's passed in 2025. The problem was a law was introduced in 2021 that prohibited persons from serving on the architectural review committee, or whatever it's called in a particular neighborhood, prohibited them from serving on a committee if they were a board member, a spouse of a board member, or anyone residing in the home of a board member. If we don't have enough volunteers in a community, it's very difficult for many associations to carry out the ARC functions that they must do under the documents. For small communities with a 3-member board, it wasn't unusual for the board to serve as the architectural review committee. But once this law passed, any board members on the ARC needed to resign, and they had to find someone. If there were no volunteers, it made it very difficult for them to operate. Now, in 2025, there is a procedure for filling the ARC committee openings. So if there's 3 on the committee and someone leaves the community, resigns, or is no longer available on that committee, the association can notify all owners that we have an opening, and if enough volunteers don't come forward by the deadline, deadline must be at least 10 days after you send out this notice to all members of the community. If enough volunteers don't come forward to fill the number of openings on the committee, at that point the board is empowered to appoint someone who would otherwise be ineligible. In other words, they can appoint a spouse of a board member. A board member could serve on the ARC. Someone who lives in the house of a board member could serve on the ACC or the ARC. So that's a really helpful thing for associations who have challenges finding volunteers for an important function like the ARC function. This is an interesting one. A lot of things have occurred in our political environment over the last quite a few years, and it was, I think, important for Texas elected officials to make sure that they were protected from maybe being discriminated against. A liberal or a conservative community not wanting the other side to have access to its residents to get out a political message. So what was added is that a POA may not prohibit an owner or resident from inviting a government official or candidates for any public office to the community to meet with owners, residents, and anyone of those who want to invite guests. Um, and so if I, for example, want to hold a meeting with any of the elected or candidates for public office, my association can't prevent me from bringing them in and inviting all the people I would like to invite to come see them. They can be in any of the common areas. Now, common areas would be things like a clubhouse, if there's a meeting room, a pavilion, the swimming pool, a park. If it's a gated community with private streets, then in the middle of a cul-de-sac. The common areas would include any areas that a resident would normally have access to. So this is not a great example, but if the invited candidate would not be able to meet in the pump room of a pool if residents don't normally have access to the pump room of a pool. But also if the meeting room is only used for board meetings and residents don't have access to it for their own purposes, then the meeting room would be off limits. An important thing about this is these gatherings would be subject to the same rules as any other gathering. So if you're required to make a reservation to use the clubhouse, pay a rental fee or deposit, those would be part of this gathering. There may be things that are limited to the time of day. You can only have meetings up until 10 p.m. or seasons of the year. You can't meet at the pool except during the pool season. If there are rules that you can or cannot serve food and beverages, they would apply. If you require meetings on the pool deck to have a lifeguard present, then the same thing would apply here. So this isn't taking over common areas or the state telling us what we can do on the common areas. It's simply indicating that we can't discriminate against government officials or candidates because of what they may be saying. We must allow them to come to a community. So this was a interesting one. To summarize all of this, there were a number of about 70 bills that were concerning POAs, but very few of them passed, as is normal. But importantly, unlike some other recent sessions, everything all the way back from 2011, there's been a lot of negative bills that were introduced and bills that had significant impact that were passed. This one's been really, really mild. And so there aren't any large ones which are place additional cost or administrative burdens or difficulties on associations. So it's been a good session relative to what has occurred in the past. At this point, I really want to thank you for watching this. We hope you found the information to be beneficial in your role as a community volunteer. And hopefully you'll check out some of the other seminars in our YouTube channel. Thanks.